Hi there, I'm Christine, and this is the Freedom Update, the bi-weekly video podcast from the Canadian Constitution Foundation, where we tell you about our ongoing cases, give you updates on interesting constitutional cases from across Canada, and tell you how you can participate in our ongoing events. Thanks for tuning in, and let's talk about freedom. This week, the CCF has been in court twice. First, on Tuesday, we were in the Supreme Court in the court battle over the size of Toronto City Council. And today, we're in Ontario Superior Court seeking an injunction to stop the federal government's quarantine hotels. Now, I'm going to start with our Supreme Court case that was heard on Tuesday. In that case, we were an intervener, and the case arises out of the 2018 decision by the Doug Ford Ontario government to reduce the size of Toronto City Council from 47 councillors to 25. It was a move that the Premier said was necessary for cost savings and to improve council efficiency. Now, the city challenged the law shrinking the size of council, and the city actually won at the lower court level. The Ontario Superior Court struck down the law, holding that it was an unjustified limit on the charter guaranteed right to freedom of expression. Now, this finding was surprising for a lot of legal analysts who didn't expect the court to rule that this was a freedom of expression issue. The Supreme Court is now being asked to consider if the legislation is valid. This is an important case because the Supreme Court is being asked to decide what freedom of expression protects and what it doesn't protect in the context of an election. Section 3 of the Charter protects voting rights. And when the Charter was enacted, when it was first drafted, the municipal voting rights were specifically left out of Section 3 protection because cities are creatures of the province. Now, we argued in court on Tuesday that the courts can't now find special protections for participating in municipal elections inside another right, like the right to freedom of expression. In our view, this would dilute the right to freedom of expression and make it more difficult to protect in future cases. We also argued that the court must insist on a disciplined approach to interpreting the Charter. Now, this case is more than just about what freedom of expression protects and what it doesn't protect. It's also about creating a consistent approach to the Charter so that Canadians' civil liberties can be clearly defined and therefore more rigorously protected by the courts. And also during the hearing, the City of Toronto also argued that the court should rely on what are called unwritten constitutional principles in order to find the law invalid. But we argued that unwritten constitutional principles are not provisions of the Constitution and can neither extend the reach of written constitutional principles like freedom of expression or expand the judicial power to strike down validly enacted or duly enacted legislation. It was a really fascinating hearing, and the CCF was really honored to have been able to participate. And we expect a ruling in the coming months. Now on to our quarantine hotel case. We're in court today, Friday, March 19th, seeking an injunction to suspend the quarantine hotel policy. We're working with 5 individuals who have all recently traveled or are imminently seeking to travel, all for compassionate reasons. Take, for example, one of our individual applicants. His name is TJ. Now, TJ delayed travel to the United States where his wife lives. His wife requires surgery and also assistance with basic tasks like washing her hair or bathing because she sustained a very serious shoulder injury. TJ wants to travel to the United States to help her, especially after her surgery's been completed, but they simply can't afford the cost of a quarantine hotel. Another traveler, his name is Jan, he's delayed travel to France where his mother, who's 92 years old and has dementia, has just returned from the hospital with a serious lung infection. Jan is his mother's legal guardian, and her likelihood of surviving the year is low. Jan wants to be able to travel to France, but he is struggling with this $2,000 quarantine hotel cost like many other travelers. And one of our other individual applicants is a man named Will, who wants to go to the United States to see his father, who has stage 4 lung cancer, and help his father and, sort of say goodbye. These are all people who are struggling with the $2,000 cost of the federal quarantine hotels. It's a significant burden for them. And for some of them, it's a complete barrier to travel. There's no good rationale for the restrictions on these travelers who deserve our help and they deserve our compassion. Canadians have a right to enter Canada, they're a home country, and we also have a basic right to liberty and to be free from arbitrary detention. The federal government has actually itself acknowledged the need to accommodate compassionate travelers. They've created a specific exemption for people who are outside of Canada and need to return to Canada for a compassionate reason, for example, to assist a loved one who needs medical assistance or to attend a funeral. But these specific compassionate exemptions are only available for people entering Canada for compassionate reasons. They're not available for individuals who have left Canada for compassionate reasons and now need to return. One of the applicants in our case, her name's Christina, she learned of this hypocrisy in the law when she traveled to Portugal to arrange and attend the funeral of her father. She asked the government for a compassionate exemption from the expensive hotel quarantine requirement for her return to Canada after the funeral, and she was denied, being told that the compassionate exemption is only if you are entering Canada for compassionate reasons. Now, this doesn't make any sense. There's no greater likelihood that Christina will transmit COVID upon returning from a funeral than if she's entering to attend a funeral. And in fact, she's already required to take 2 COVID tests. So the risk in our view is low, and the law is hypocritical. But the nonsensical nature of these quarantine hotel requirements shouldn't come as any surprise to us. The federal Minister of Health has herself admitted that there's a lack of complete data to support the quarantine requirements. She said this in her committee appearance on March 10th. Now, in the absence of data, the experience of some other jurisdictions that have used quarantine hotels can be helpful. For example, Australia had a second wave of COVID that was reported to have been triggered by these quarantine hotels. Hotel security contracted the virus from a guest and then introduced it to the community. There's also been guest-to-guest transmission in the Australian quarantine hotels. This is the type of risk that Canada is running by requiring hotel quarantine. Individuals who have already stayed in these hotels have actually complained about the environment, which some have called complete pandemonium, with dozens of guests congregating in hotel lobby, minimal to no social distancing, and improper masking. In the interest of both safety and justice, the federal government should repeal the quarantine hotel requirement, but until that happens, we're going to be in the courts. We expect a result of the injunction will be released very soon, likely in a matter of days, and we'll be sure to keep you updated through this video update and through our mailing list, which you can subscribe to at theccf.ca. There's some interesting constitutional developments from across Canada, but since I had a longer update on our 2 cases in court this week, I'm just going to give you a quick update across Canada. I wanted to point out that there are actually 3 other challenges to federal quarantine hotels. 2 of those challenges are in Alberta, and the other one is in Quebec. The Quebec challenge is going to be heard in early April, and it's being brought by a family reunification organization called Faces of Advocacy. So I'll be sure to keep you updated about the progress of those cases as well. We just wrapped up our annual Law and Freedom Conference put on by our friends at the Runnymede Society, but we have more events in the works. I'll be participating in a panel at the Canada Strong and Free Networking Conference, formerly known as the Manning Networking Conference, that will be taking place on April 10th. The debate I'll be moderating is about whether or not political beliefs should be protected by anti-discrimination laws. It's sure to be a very lively conversation. You can register for that event and for the full conference at canadastrongandfree.network. I'd also like to remind everyone that you can watch my new television program, Canadian Justice, every night at 8 p.m. on the News Forum. That's channel 1514 on Bell, or you can access the episodes at thenewsforum.ca. That's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.